my name is Stephen Goldie, and I am the head of litigation at Brodie's. I'm joined today by two of my colleagues in our business disputes team, Jared Oyston and Ross Campbell, both very experienced lawyers, dealing with contract disputes, all manner of different things that they've got on at the moment. I thought it'd be useful just to kick off by letting you know how we have been handling our business during the health crisis. We have 150 people in the disputes team working from home. Nobody has been furloughed. Our teams are still busy providing solutions on a range of ongoing mandates in court. That's a little bit more challenging just now because the courts have done things like discharge hearings for the period from March through to August, but they've started doing things remotely. Took a bit of time, but we're getting there. But we've also got a huge amount of alternative dispute resolution on the go through arbitration, so that's private courts. Jared has quite a big arbitration hearing coming up, and that's all going to be done remotely. I'm not going to comment much more on the public court, the private court debate at this point in time. That's for another day, but there's things still ongoing. But more than ever, what we're seeing is a huge amount of advisory work in the disputes team. So we're seeing a lot of urgent business problems coming from existing clients and new clients. And of course, that includes COVID-related issues. The main categories, if I could do that for you so far, include contract work, so termination, variation, tension, which of course includes we're going to speak about today of force majeure and frustration, and also, of course, balance sheet protection for clients. So that includes cash collection and deals being done and some variation of contract in there. A huge amount of time has gone into advising on the consequences of government intervention. So, for example, there's been legislation passed, regulations coming into force, and that's on top of government guidance at various key points throughout this particular health crisis. Consequences of regulatory intervention is also a topic which is high on the agenda, and there may be some unintended consequences there if you're looking at things like wrongful trading being relaxed at this point in time. However, today we're going to concentrate on contracts, and in particular force majeure and frustration. Now, I promise you we will attempt to put that into context of the current health crisis. And there's one thing for everyone to note at this point. Contracts are not entered into in a vacuum. The parties can always allocate risk and reward, and hopefully they do that through very clear language. Unprecedented. That's a word that we are constantly hearing at the moment. But is it true? On my first slide, I've set out a famous quote from Donald Rumsfeld, who was, of course, the Secretary of Defense for the US in 2002. Now, this quote actually makes me feel quite old, because I remember the press conference at which Donald Rumsfeld started to articulate that there were known knowns, known unknowns, and unknown unknowns. Pausing here, you should all reflect on how you would characterise the emergence of COVID-19. Secondly, how would you characterise the government response in relation to COVID-19? In theory, at least, and as a court might look at it, they are two different things, yet they are interlinked. The business likes to think that they can plan for everything. I don't think anyone would have envisaged that their business continuity plan would involve us all being at home for at least 2 to 3 months, perhaps even longer. But at the same time, we've also got all our customers and many other businesses with their people at home, confined to home, in fact, under government legislation. So what is this health crisis? Is it a known unknown, or was it an unknown unknown? Looking back through the mists of time, there's always been major instances of disease, ranging from the Spanish flu in 1918 to the likes of SARS and Ebola more recently, of course. Having looked into some of these things and their impact on the economy and what clients did during some of these periods, It's interesting that there have been other major epidemics that the UK has had to grapple with. So in 1968 and 1969, there were two waves of a flu epidemic known as Hong Kong flu. Now, the UK National Data Records report that the Hong Kong flu was responsible for 80,000 deaths in those 2 years. 20,000 people died in 1 week alone during that particular epidemic. Now, economists have been pointing out that there was no lockdown at all over that period. But, you've got to be careful about making comparisons. There's no direct comparison. It's a different time in history. It rarely is a direct comparison. So when we come on to look at things in the context of a contractual analysis, you have to just look at what's in front of you right now and what you're dealing with now. Turning then to modern contracts and COVID-19, Ross Campbell is now going to take you through the nuts and bolts of force majeure clauses in contracts. And we've left plenty of time for questions, which we would ask you to submit through the Q&A function. Thank you.
Thanks, Stephen. I'm going to give a brief overview of the doctrine of force majeure and highlight some points to think about. Although most contracts contain force majeure provisions, generally they're quite unusual. It's quite unusual to have to rely upon them. However, as we all know, the situation we're in just now is anything but the usual. And with the outbreak of COVID-19, all of a sudden businesses are more conscious of force majeure clauses in their contracts and trying to work out whether or not they might come into play. So I mentioned at the top of my next slide, really that a clause will generally excuse parties from performance of contractual obligations when events happen which are beyond their control. So when we're talking about a force majeure clause, the term, as you might guess, comes from French law and means superior force. And they will generally excuse parties and refer to things like acts of God or war or government interference, or more general terms like events which are not reasonably foreseeable or beyond parties' reasonable control. However, it's important to note that whilst those are examples, there's no default or technical definition of force majeure in the UK, and it will not apply automatically as a matter of law. This is different to other countries where there may be a statutory definition, or it's a standalone doctrine which will apply whether or not a contract contains specific provision for it. Or as you may have seen, some businesses in China, for example, have been issued with certificates which confirm that the current outbreak should be deemed a force majeure event. But in the UK, it's a creature of contract and will only apply to a contract governed by Scottish or English law if that contract contains force majeure provisions. And that may involve a specific force majeure clause, as is often the case, or there may be provisions elsewhere in the contract, such as in the default or termination provisions, where it may not mention force majeure, but it might be a basis for termination if a particular event prevents performance for a specified amount of time. So quite understandably, with the prominence of the term in the media at the moment, businesses are asking if this doctrine might assist them. But unfortunately, there's no simple or universal answer to this. It will depend on what the particular contract says. And that applies not just in relation to whether the coronavirus outbreak might fall within the definition of a force majeure event, but also what the consequences of that will be. So taking a practical example, a drinks company has a contract which requires it to supply a fixed number of products to distributors or customers, who will then sell these at profit. As a result of the measures which are currently in place, there's an issue in the supply line. For example, an important ingredient can't be sourced, or the manufacturer of the bottles is closed, all of their operations, and it's not possible to bottle the drinks. If there's a force majeure clause in the contract, the particular wording used may determine whether the supplier can be excused for failure to supply the products and prevent, for example, a claim by the distributor for loss of profits. This sort of example will be relevant in a variety of sectors. It may also apply in the construction or house building industry if there are materials which can't be sourced, or if there's a breakdown in the supply chain in relation to these materials, or even in relation to the supply of contractors. Or maybe the social distancing rules mean that particular work can't be carried out at the moment. It may also be particularly relevant for the likes of local authorities, which may see interruption across a whole range of areas. So, I've mentioned at the top of my next slide, does the force majeure clause apply? I've listed their generic definition, exhaustive list, or a combination of the two. Now, these clauses may range from something very generic to a comprehensive list of events, but if it's too generic, such as a reference to force majeure events without defining what these are, then there's a risk that the clause will be found to be too uncertain and might be found to be void as a result. And then if there's a list, then there's a risk that that might be seen to be exhaustive. So there would usually be a catch-all sweep-up provision at the end to ensure that the list is not treated as exhaustive, and therefore you'll usually see a combination of the two. I referred earlier to the use of language such as act of God or war. It's also not uncommon for a force majeure clause to refer to the outbreak of disease or virus, or an epidemic or pandemic. Obviously, wording like that is going to be helpful in the current circumstances if you're looking to rely upon the clause, as will government intervention, given the measures which have been enforced by the UK government. But where there may be more of a dispute is where more general wording has been used. For example, what does any event which is beyond parties' control or not reasonably foreseeable actually mean? When's an event unforeseeable or beyond a party's control? It will depend on the exact wording which has been used, and the surrounding circumstances and context may also be relevant to the interpretation of the clause. Unhelpfully, there doesn't appear to be any UK case law which tells us authoritatively how the outbreak of a disease will be treated. This is maybe not surprising given the unprecedented nature of the disruption that the coronavirus has caused, and in any event, as each case will likely turn on the wording used in the particular clause, parties may seek to distinguish the wording which has been used in their own contract from that which a court has decided upon. Something which also may be particularly relevant when determining the more generic wording, or the meaning of the more generic wording, is when the contract was entered into. For example, the interpretation of the term not reasonably foreseeable, if this forms part of the clause, may be very different in a contract that was entered into last year and one that was entered into or even renewed at the beginning of this year, when the coronavirus had already led to widespread disruption in China, and it might be argued that the spread of the disease in other countries was foreseeable. Now, I mentioned renewed because there will undoubtedly be a number of contracts which were renewed relatively recently on the same terms as before, almost as a matter of course, or even new contracts entered into using standard terms. So the timing of entering into these agreements may be critical in terms of whether the wording is sufficient and what might have been foreseeable at that point. And businesses will no doubt be giving careful consideration to what goes into any new contracts they're entering into at the moment, particularly when, although we might start to see a relaxation of the measures which are in place, we're constantly being reminded of the looming possibility that there may be further lockdowns in future. So they can be quite troublesome clauses. They've been referred to as effectively involving parties to a contract trying to predict the unpredictable and put appropriate provisions in place for events which, by their nature, are generally supposed to be unforeseeable. Very generally, with the type of disruption which has been caused right now, where people are being told to stay at home and basic commercial activity is effectively suspended, it would seem likely that in most cases, if a contract contains force majeure provisions, they will be triggered to some extent by the current outbreak, and it might be difficult to argue that the clause was not intended to apply to the sort of global lockdown that we're all facing at the moment. That being said, though, it will depend what's in the contract. Now, another point to consider, which I've mentioned at the top of my next slide, is whether an event, even if it does fall within the definition of force majeure, is actually the reason for non-performance. For example, it may well be that a force majeure event has arisen, but the reason for non-performance is entirely unrelated. A party might be struggling to hit sales targets anyway, or to finish a job on time, or to provide particular services. Or it might be that a commercial arrangement might not have been as profitable as a party might have hoped, and they're looking for a reason to end the contract without incurring liability for damages. The current situation might then seem like a convenient excuse in those cases, but the wording of the clause will usually look to guard against that and contain some provision which makes it clear that it must be the force majeure event which affects performance. Even then, a dispute may arise, and there was an English Court of Appeal case last year that provides quite a good example of this. It was stated in this case that a party seeking to rely upon a force majeure clause needed to be ready, willing, and able to perform the contract, but for the force majeure event. That was the classic maritime case that I've referred to in the slides. In that case, the defendant was a charterer of a ship owned by Classic Maritime and had to ship iron ore from Brazil to Malaysia. A dam burst, production of the iron ore stopped, and the defendant said it couldn't make the shipments as a result and was sued by Classic Maritime. There was a clause in that case that the defendant sought to rely upon, which said that the defendant would not be responsible for failure to deliver cargo resulting from accidents at the mine or production facility or any causes beyond the charterer's control, provided that any such events directly affect the performance of either party. The defendant, when relying upon the clause, had some difficulty because it was found that on the facts that the defendant couldn't have performed its obligations anyway due to a collapse in demand for the cargo in Malaysia. And in fact, there had been no shipments in the months leading up to the accident. So it was said that the defendant was not ready, willing, and able to perform its obligations but for the accident, and therefore couldn't rely on the clause. Now, in that case, the clause specifically referred to the events directly affecting performance, and clauses won't always be that explicit. It also looks as though this case might be making its way to the Supreme Court, so it may not be the end of the matter, but it does perhaps demonstrate the degree of uncertainty that may arise when there is another reason for non-performance. Related to this is what the clause says about the actual impact of the event. Often the clause will refer to the force majeure event preventing performance. So in those cases, if performance has just been made more difficult or uneconomical, the clause may not apply. Using, for example, the purchase of materials or supply of labour in a construction project, it may still be possible to obtain the materials or labour, but it may be more difficult or expensive and affect the previous profit margin. The challenging party will likely then argue that performance has not actually been prevented. Should be noted, though, that it will not always be necessary for a party to be prevented from performance. Clauses will often refer to them being hindered in their performance, which will apply in much wider circumstances, or possibly to being delayed, which again will usually be easier to satisfy. The next thing to consider, if the clause does apply, and I mentioned at the top of my next slide, is what the consequences of that will be. It may, for example, give rise to a right to terminate the agreement, whether immediately, which is more unusual, or once the force majeure event has continued for a specified period of time. Alternatively, and more usually, it may simply suspend parties' obligations, or it may extend deadlines for performance, or excuse a party for failing to perform obligations on time, although it may not excuse a party from all of its obligations. It may only be a specific obligation, or only those obligations which are actually affected by the event. If it's agreed that there will be no liability for losses arising as a result of the failure to comply with the obligations, this may prevent a claim for damages, for example, or it may be the case that one or both parties will not be required to make particular payments under the contract. The final point I noted there in that slide is that parties may simply agree that they'll take stock and renegotiate if particular difficulties arise. That may be the commercial approach and would allow parties to map out their intentions to try to sort something out. But if there's not enough specification about what actually will be done, it may amount to an agreement to agree, which might not take parties very far in terms of an enforceable right, and some level of certainty may be preferred. Again, it will depend on the circumstances. Now, as a final and practical point that I mentioned in my next slide, it's important to check whether there are any notice provisions in the force majeure clause. It may state, for example, that a party will be excused from performance, but in order to trigger the clause, that party is required to give notice. So it may state that you need to give 14 days written notice that you consider a force majeure event has occurred. If this requirement is not observed, the right to rely upon the clause might be lost. So it's really important not to ignore this. Some consideration should also be given to the triggering event, which it's claimed is preventing or hindering or delaying performance. It might seem like a fine distinction, but it could be very important to the time that the clock starts ticking. For example, if the trigger was the declaration of a pandemic, this will be an earlier date than the imposition by the UK government of the lockdown measures. So it's worth being clear on the particular reason why the clause is being relied upon. It's also worth cross-checking such a provision with the general notice provisions in the contract, as if, for example, all contractual notices required to be given in writing by recorded delivery and email notification will not be sufficient. There is a risk that disruption to the postal service delays the service of a notice. So hopefully that gives a flavour of some of the things that you might think about when considering the application of force majeure. Ultimately, as force majeure is a contractual concept, the circumstances in which such a provision will apply and the consequences this will have will depend upon the particular contract. And when there's disagreement about the correct interpretation of the clause, unless parties can come to a commercial agreement, the matter unfortunately may end up before the courts. So if you do find yourself in a situation where you are seeking to rely upon these clauses, it would be good practice to keep a detailed documentary record of the basis for this, as well as any communications in which a variation of the existing contract might have been agreed. just in case it's necessary to demonstrate this further down the line.
Okay,
So I was just going to say just to the end, if there's no force majeure clause or any provisions with that effect in the contract, the doctrine won't apply. And in these circumstances, we might need to look to frustration instead. And that's what Jared's going to talk about. So I'll pass over to him.
Just before we go on to Jared, Ross, there's some questions coming through already on force majeure. It might be a good point just to take those questions just now, if you're happy to do so.
Sure. Yep. Okay,
so one coming through. To what extent do you think that force majeure clauses will change going forward?
Well, I think that it's certainly going to put them in sharper focus, and possibly because of how uncommonly they've been used in the past, people have maybe not paid as much attention to them, and I think that parties maybe will take a bit more time. I mean, you referred to the unknown unknowns at the start, and to an extent it is planning for the unknown unknowns, but I think that they may change in that they might be more comprehensive, and parties will want to be sure that they can rely upon in circumstances like these.
Yeah, we've already seen our corporate colleagues been asked to advise on deal structures and also specific clauses in force majeure. You won't be surprised to hear. And of course, they're being bolstered to take account of what we now know about the impact of this particular virus. So yes, that they're being bolstered just now. Okay, another question coming in here. This is about, what types of contract are you advising on already, Ross?
We've seen them come in a variety of situations. I mean, we've had them in the sporting context due to obviously the suspension of leagues. They seem to crop up in the hospitality industry due to various bookings being cancelled. Also seen manufacturing issues and in relation to energy companies as well.
Okay, thanks, Ross. Well, I think, we'll try and come back to some more of the questions. I'm just conscious we want to get through Jared's section. I think that frustration of contract is quite an interesting area and one where there may be scope for quite a lot more argument, of course, because it's not a contractual provision as such. So, Jared, can you lead off now on frustration, please?
Yeah, thanks, Stephen. So after Ross has just taken you through force majeure, which in the UK at least is all about what the parties have agreed as regards the impact of supervening events, I'm going to give you a brief overview of frustration, which is all about the impact of supervening events which the parties haven't foreseen and haven't catered for in their contract. So it's important to note that frustration is a standalone legal doctrine. It does not depend necessarily on what is in your contract. Obviously, when looking at whether or not frustration may apply, you will usually need to have a look at certain of the provisions of your contract, but it is not as simple as looking at the contract to see what it says about frustration. By its nature, generally speaking, a contract will not contain anything relating to frustration and when it will apply. So what is the legal doctrine of frustration? Generally, the English and Scottish law applies the principle of absolute contract, in which parties are expected to perform their obligations and they are taken to have considered the risks that might affect that performance. However, the doctrine of frustration basically recognises that sometimes events occur which are so outside what was envisaged by the parties and which strike so directly at the heart of the contract that actually justice would not be served by holding the parties to their obligations. However, the court does apply a high bar in this area to ensure that what is supposed to be an exception to the general rule does not end up being used by parties to escape the consequences of bad bargains or poor planning. So what does that high bar look like? It's set out on the next slide. So the test that the courts will apply when considering whether a contract has been frustrated is that they will ask whether an event has occurred after the contract has been formed, which is not due to the fault of either party, which will be regarded by both parties as going to the root of the contract, was not within the contemplation of the parties at the time of contracting, and which renders further performance either impossible or so different from what the parties contemplated at the time of the contract that it would be unfair to hold the parties to that performance. And on the next slide, we have some examples of events which the courts over many decades have considered do have the effect of frustrating a contract. The first one on the slide there is destruction of the subject of the contract. This goes back actually to what is, I think, the very first case in England in relation to the frustration of a contract. And this concerned a contract in which the owner of a stately home agreed to let it out to a party for the purpose of holding concerts and a festival. And in the intervening time between the making of the contract and the performance of it, the stately home burnt down. And the court held in that case that the contract ought to be discharged and frustrated on the basis that the very root of this contract was the stately home. It was a contract for the renting of that home for a specific purpose, and that purpose would could no longer be fulfilled, and accordingly the parties should be discharged from their outstanding obligations under the contract. Another area in which it is usually fairly uncontroversial that frustration should apply is where an event has occurred which would render performance illegal. So generally speaking, the courts do not consider that the parties will have agreed in their contract that they will perform their obligations come what may, even if that performance would put them in breach of the law. So a good example of this would be, for example, if a party had agreed to provide certain goods or services to a Russian company in 2013, the imposition of EU sanctions in 2014 might have the effect, depending on the precise nature of the contract, of rendering performance illegal, and that would be an example of a frustrating event due to intervening illegality. Similarly, the cancellation of an event. The cancellation of an event which is deemed to be at the very core of a contract can have the effect of frustrating that contract. And again, there's a seminal case in relation to this point, in which the owner of a flat overlooking Pall Mall agreed to let that flat for a number of hours on an afternoon in 1903 in order that the renting party could use the flat to view the coronation parade for the new king. Unfortunately, the king fell ill and the coronation parade had to be cancelled. And the owner of the property argued when seeking the balance of that payment that the ability to view the parade was just incidental to an ordinary rental contract. It did not go to the root of that contract. And the court disagreed and found that the root of the contract, in truth, was the ability to view this coronation parade, and the cancellation of that parade frustrated the fundamental purpose of the contract, such that the parties should be discharged from their obligations. And finally, unforeseeable delay. Generally speaking, delay will be a much more difficult argument than saying that an event has been cancelled or an asset destroyed. But sometimes a delay can be so severe and so unexpected that it is beyond what the parties had envisaged at the time of the contract. And an example of this would be a case in England in which a party agreed to deliver goods to a specified port, and their ability to deliver goods to that port was frustrated on multiple occasions by the fact that there was an ongoing strike among the dock workers. And it was held in that case that the delay went on so long that even though performance was technically possible, the parties could just wait out that strike. By the time they had done that, the purpose of the contract effectively would have been frustrated, and therefore the parties should be discharged from their obligations. We're going to look now on the next slide at a few events which, generally speaking, the courts have held will not be capable of frustrating a contract. A key one is where the event in question was already apparent or foreseeable at the time of the contract. This ought to go without saying, but the law of frustration really is about events that the parties did not foresee at the time they entered into the contract. If an event is foreseeable or indeed already apparent or underway, and the parties have not in their contract provided for how that event and any risks associated with it will be dealt with, they are taken by the court effectively to have just accepted any risks that may arise from it, and that they will lie where they fall. In a very similar vein, where a contract makes an express reference to what is to happen in the case of an event, then that will generally speaking not be capable of frustrating the contract. An example of that, of course, would be a force majeure clause, as Ross has just outlined. Similarly, where an event is due to the default of one of the parties, frustration is all about external events impacting on the party's bargain. If one of the parties has actually caused that event through their own default, then frustration won't assist them. So, for example, in the case of the stately home that we discussed on the previous slide, the outcome of that case might have been very different if actually it was the case that the owner of the property had breached obligations to keep the property in good order, and that the breach of those provisions resulted in the damage to the property, which rendered the contract frustrated. Similarly, a contract generally won't be frustrated where there is an alternative method of performance available to a party. And similarly, even if that method of performance would be more expensive for the party, that too will not generally be a frustrating event, nor generally speaking will changes in economic circumstances, which are viewed as being part of the general risks that commercial parties take. And a good example that illustrates a number of these points on this slide was a case from the late 1950s in which a shipping company agreed to transport a consignment of groundnut oil from Sudan to a port in Europe, and the contract provided that it would transport those goods via the customary route, or if that was not available, another reasonable route. The customary route at that time, and indeed now, is the Suez Canal, but due to the Suez crisis, the Suez Canal was rendered inoperable at that time. And the shipping company argued that the effect of that was to frustrate their contract, and it was at the heart of the contract that the goods would be transported via the Suez Canal. And the court disagreed with that, and on a number of the bases set out in the slide, in particular, there was an alternative method of performance available. The goods could be transported around the Horn of Africa in the way they would have been had the Suez Canal not been there. The shipping company argued that to do that would have been twice as expensive and would have rendered the contract entirely uneconomical from their perspective. But again, the fact that a contract has become more burdensome or less attractive economically will not generally frustrate a contract. And furthermore, the court also placed quite a lot of weight on the fact that the contract had expressly referenced the possibility that a customary route might not be available, sea lanes closed. The contract expressly provided that if the customary route was not available, another reasonable route could be used. So for all of those reasons, the court declined to find that contract had been frustrated, and therefore the party which had failed to deliver that consignment of goods could be sued for breach. In terms of the consequences of frustration, conveniently, the law in England and Scotland is now broadly similar. They did differ until 1943, but in 1943, a Law Reform Act was brought in, which effectively brings the consequences of frustration in England and Wales into line with the position in Scotland. And what those bodies of law provide is that the contract is discharged at the point of the frustrating event. Money paid before a frustrating event can be recovered. Money due but unpaid following the frustration event is no longer payable. However, the law recognises that could have quite damaging effects on a party in circumstances where the sequencing of the party's obligations means that one party, as at the date of the frustrating event, has already performed some, most, or indeed all of its obligations under the contract. And accordingly, the legislation in England and indeed Scots law generally provides that where a party has incurred expenses prior to the frustration event, the court may allow it to retain or recover an amount in respect of those expenses. And similarly, if a party has gained a valuable benefit under the contract prior to the frustrating event, it may have to account for that benefit by paying what the court deems a just sum in relation to it. So having looked at the general principles and the consequences of frustration, we're going to now apply these to a couple of simple examples of situations that might arise in the COVID-19 environment. So in our first example, we have a bus manufacturer, Bus Builder Limited, which agrees to supply 5 new buses to a Scottish tour operator, Scott Tours Limited. Scott Tours pays a 30% deposit, and the balance is payable upon delivery. Delivery is due at the end of April, which is in time for the peak summer tourism period, which is when Scott Tours makes most of its money. We're assuming in this example that the COVID-19 lockdown does not prevent Bus Builder Limited from delivering its obligations, which is to deliver the buses on time, and Bus Builder is indeed able and ready to deliver. However, due to the COVID-19 lockdown, almost all of Scott Tours' summer bookings have been cancelled. They are currently unable to deliver bookings, even if they had any, and there is no clarity over whether or not there will be a summer season this year at all. And accordingly, Scott Tours effectively no longer needs the buses. And that gives rise to the question of whether the contract has been frustrated, whether Scott Tours has to pay the balance upon the delivery of the buses by Bus Builder, and indeed whether Scott Tours can go one step further and recover its deposit. So the key considerations that the courts and indeed the parties ought to be looking at in this case are, first of all, the starting point is, are Scott Tours' outstanding obligations now impossible for it to perform? And those obligations are to accept delivery. That's an implied term of a supply contract, to accept delivery of goods which are delivered in accordance with the contract. And secondly, to pay the balance upon that delivery. Now, it's open to argument, but I think it's fair to say in this case that actually both of those obligations are possible. It's possible for Scott Tours to perform them. It can accept delivery of the buses, subject to any change in the COVID-19 lockdown environment, and it can also pay for those buses. Now, what we mean here is that it is possible for the Scott Tours to make payment in the sense that it might have access to external financing, it may have saved some money due to furloughing staff, and so even if it is not able to pay that sum in the way that it had hoped, i.e. from advance payment on all of its summer bookings, in principle, it is still possible for it to find those funds and to pay. So that brings us on to the second question, which is whether the obligations are so fundamental whether the impact of COVID-19 changes the obligation of Scott Tours so fundamentally that it is unfair to expect them to honour those obligations. So if we just go back one slide. And really this is a question of what is at the heart of this contract and whether or not the impact of the lockdown goes to the root of that contract. And in particular, in this case, Scott Tours would argue that at the very heart of this contract was the prospect of the summer 2020 period. They would no doubt point to the fact that the parties agreed an April 2020 delivery. They would perhaps point to discussions that they had with Bus Builder on why they wanted that delivery and the importance to them of prompt delivery on that date in time for the summer 2020 period. And in that way, they would seek to frame this contract as being all about summer 2020. I think, though, it's fair to say they would be on something of an uphill struggle in that regard, in that Bus Builder would no doubt point to the fact that this isn't a lease contract, this is a purchase contract. It is a purchase of substantial assets with a lengthy life, and there will no doubt have been provisions in the contract about ensuring that those buses have the lifespan that of many years. And accordingly, I think Bus Builder would have a good argument that the summer 2020 period, no matter how important it may well have been to Scott Tours, was not fundamental to the contract. It was not the root of the contract. Finally, another consideration that Scott Tours would need to take into account here is whether or not, even if the contract is frustrated, it would be able to get all of its money back. There's a risk here of Scott Tours, even if it was successful, winning something of a Pyrrhic victory, because even if they obtained a court judgment requiring the return of their deposit, there would be a real risk that Bus Builder would be entitled to deduct from that deposit and indeed possibly seek a further payment covering the expenses it had already incurred in building these buses, kitting them out, etc. And so it may well be a case here of be careful what you wish for, in that frustration might not be, economically at least, the relief that Scott Torres is looking for. So moving on to example 2. In this example, in February 2020, Food and Drink Limited agrees to provide Oil and Gas Limited with catering facilities for a rig which is to be deployed in the North Sea in May 2020. And Oil and Gas Limited pays a deposit to Food and Drink Limited in anticipation of the provision of that service. So as oil energy is an essential industry, UK lockdown measures do not prevent Oil and Gas Limited from deploying the rig in May 2020. However, in April 2020, with the oil price at historic lows, Oil and Gas Limited decides to postpone the deployment to an unspecified future date. It then seeks a refund of its deposit paid to Food and Drink Limited on the basis that the COVID-19 crisis was a frustrating event. Now, again, the first question to ask is, does the alleged frustrating event prevent performance of the obligation? And the obligation in this case is for Oil and Gas Limited to pay Food and Drink Limited. And again, I think Oil and Gas Limited would be facing an uphill struggle if they were to argue that it is now impossible for them to fulfill that obligation. It may well be much less convenient and much less economical for them to make that payment, or to not pursue repayment of the deposit in circumstances where the rig is not being deployed, but it is not impossible. And that brings you on to the second question, which is whether or not the COVID-19 situation makes Oil and Gas Limited's performance of the contract so different from what was envisaged at the time of the contract as to make it unjust to expect it to perform. And again, although it is more difficult in this situation for Oil and Gas Limited to pay sums or not be able to recover sums from Food and Drink Limited, there is a real risk that a court would look at this and take the view that movement in oil prices, slumps in demand, are factors which a business in an Oil and Gas Limited's position always takes into account in virtually every decision that it makes. And therefore, the impact of a significant slump in demand and a decline in the oil price does not render the obligation that Oil and Gas Limited entered into fundamentally different from what it thought it was entering into at the time of the contract. And finally, even if COVID-19 and or the drop in demand for oil and the slump in the oil price could, in principle, represent a frustrating event in this case, I think the court would have to, and the parties would have to consider whether the fact that the contract was entered into in February 2020 means that the potential frustrating event was actually already foreseeable to the parties. And in particular, although in Europe, COVID-19 may not have been at the forefront of people's minds in February 2020, the slump in oil prices and demand for oil was being driven very much by decline in demand in China, which very much was underway, and indeed the COVID-19 situation was peaking in China in February 2020. So I think there'd be a real risk in this case that the court would find that this was an event which ought to have been in the contemplation of commercial parties in the position of Oil and Gas Limited in February 2020. So those are the two key examples that I was going to run through. Other than that, I'll hand back to Stephen, and very happy to take questions.
Okay, thanks, Jared. And there are a number of questions coming through on frustration. So why don't we move straight on to frustration? And there's some questions we'll come back to on force majeure. So on frustration, Jared, does illegality relate only to the subject matter of the contract? Or could it be argued that government rules mean it's illegal for, say, for example, contractors' personnel to be on site to deliver the contracted for services, i.e. the services cannot legally be delivered?
Yeah, it's a very good question, because I think a lot of businesses at the moment are struggling to work out in a situation of very limited government guidance whether or not services they provide, sites they operate, are indeed essential, and whether they risk breaching the law by keeping those sites open. Equally, they don't want to be too cautious in closing those sites or stopping those services for risk of breaching contracts. I think it is important that parties look at the law in the round, and, for example, in a situation where it may well be that actually they are not obliged to close a site, but, for example, the levels of staffing they have available might be quite adversely impacted by COVID-19. And therefore, it's important for them to consider, for example, the health and safety and other regulatory impacts of operating sites, possibly legally in terms of the COVID-19 guidance, but at the same time in breach of other laws that they are always subject to.
Okay, it won't surprise everyone to hear that our contentious construction team in particular just continues to be extremely busy as people worry about what's coming out of their site. But certainly when guidance was starting to be issued, and you have to bear in mind that there was a slight tension between the UK and the Scottish guidance on this, but certainly no legislation came out of UK government to suspend operation of sites. And there was a lot of pressure, I think, put on contractors in Scotland through the kind of Scottish government guidance, although again, that didn't quite make it into the legislation in the way you might have thought. There was definitely a key point in all this in Scotland, and that was on the 26th of March when the regulations came out, which put into law the premises which had to close. But even then, when you look at those regulations, you have to be quite careful because there's nuances in there and that you have to be aware of when you're kind of doing it on a case-by-case basis. Back to force majeure, again, for you, Ross, and a question which is quite a general question. When will a force majeure event be deemed to have begun? What are the considerations you have to look at for that?
Well, it really depends what your contract says is the triggering event. So if you have an event that is a force majeure event, then when that actually commenced might depend on what your contract says, or it might be, as I mentioned before, if you're relying upon the government interference, it might be when that begun. If you're relying on a clause which says that the declaration of a pandemic will bring the clause into force, then it would potentially be the date that the pandemic was declared.
Okay, good. And another question, we're operating on the basis that force majeure does not excuse a payment obligation. Are there any known exceptions to this that you're experiencing?
Well, again, it's a case of what does your contract say. There will be some contracts which do say that the consequence of the force majeure event is that someone is excused from a payment obligation, although usually that will be a payment obligation that's in some way linked to the force majeure event. So the reason why you're not going to have to pay is because of the impact. So I think really in answer to the question, it depends on the contract. If the contract doesn't say anything about excusing payment obligations, then it may well be that it doesn't apply to those.
Okay, and a follow-up question, can government interruption or interference, at least by the Scottish government, be legitimately considered the catalyst for force majeure when it is only guidance that has been issued and not legislation?
Well, if your contract says government interference, then I think that could be seen as interference from the government. I mean, I think even though there might not be official direction, people are being told to keep a certain distance from each other. So there might also be the interaction with health and safety rules in terms of making sure that you comply with them. And on that basis, actually, the fact that we have this guidance might be enough to bring into force that clause. There might be an argument over it, but I think certainly there would be some legitimacy in looking to rely upon it.
Okay, and just switching over to frustration again. Jared, for something that could end up as an action under frustration, it seems like alternative dispute resolution could be useful to be able to come up with a satisfactory conclusion. Have you seen ADR being used before for a case of frustration? Could it be brought under the current circumstances? And I think just thinking out loud about that, then a lot of the contracts that we deal with already have ADR clauses in them, whether it's escalation or arbitration or expert determination, just depends on the type of contract and what the parties have agreed. And certainly something that we've been mulling over here as a business which has quite a large number of court actions paused, is whether we should actually be saying to commercial clients, this could happen again. So if you want to make sure you've got a route to a resolution, then really you must consider having ADR clauses in your contracts, because at least that way you'll be able to make progress in the event that there was to be some kind of repeat of the current health crisis, which is entirely possible. But Jared, what were your thoughts on that about ADR being used?
Well, to answer your very first question, I am actually dealing with at the moment with an arbitration in which force majeure is an issue. It's not COVID-19 related, but that just goes to show that there's no reason at all why force majeure and issues like frustration cannot be dealt with by an arbitral body just as easily as they can by a court. And I certainly agree that parties should consider at this time, if they have an issue in relation to contractual frustration, whether even if their contract doesn't provide for arbitration or indeed any other form of alternative dispute resolution, to consider whether it might be right for mediation or arbitration, because these are issues which parties very often will want to have resolved very quickly. If, for example, parties have reached an agreement in relation to an event taking place later this year, there are other modes of dispute resolution which might allow the parties to get some legal guidance from an arbitrator or a mediator in relation to how the parties should approach that and what their rights and obligations coming out of it are, which they arguably would struggle to get at the moment from the Scottish courts or the English courts.
Okay, now switching from business perhaps to, which seems like quite a kind of personal question here, where events such as weddings are cancelled, as venues cannot hold the original wedding date due to government restrictions and cannot offer an alternative date, could that be an example of a contract that would be frustrated?
It would depend on the contract. So a contract, for example, with somebody like a wedding planner, it would be quite easy in that situation to argue that the wedding is at the very heart of the contract, and therefore, if the wedding were to be cancelled or postponed, that contract has been frustrated, and you might not necessarily need to make payments to your wedding planner. What might be more difficult is in relation to sort of ancillary services around the wedding, in particular hotels. I spoke before about the case in which the owner of a flat argued that the ability of a party to view the King's coronation parade from that room, that the room in question was just incidental to the contract the parties had entered into. The party could still come and enjoy that property for a few hours on that afternoon. I think it is inevitable that some hotels, whether with the people who are getting married themselves or with their guests, might well try to take the line in that situation that we entered into a contract with you for the use of certain accommodation. The fact that you are, particularly guests, the fact that you are no longer coming for the purpose of a wedding is incidental to our contract, and therefore it's not a frustrating event. So I think something like a wedding will be a real area of contention across a range of different types of contracts that are entered into, not only by the people getting married, but also their guests.
Okay, thanks, Jared. We're starting to run out of time here. There's still a number of questions in here. Some of them are actually quite technical questions. It wouldn't surprise you there's a number of questions in relation to NEC contracts and SBCC works contracts, both in relation to force majeure and also frustration. I think what we'll do is we've got your names of those for the people who have asked those questions. And I think what we'll try and do is follow up with you after this. I suppose just to round off, I have a question for Jared and also for Ross. What would you, how would you encapsulate the three important takeaways for force majeure, Ross, and also Jared, how would you do that for frustration?
Well, as I said, it's a creature of contract. So first takeaway, read your contract, see how it applies and what circumstances does it apply. Second point, I would say keep good records, because if you're going to have to rely upon the clause, then you're going to want to be able to show your thought process as much as possible and have documentary evidence. And the third point, as I illustrated there, if you are going to end up in a dispute, then there might be considerable uncertainty in relation to the interpretation of more general clauses. So really, if you're in a position to try to agree things on a commercial basis, then parties, I'm sure, would be much more prepared to do that rather than risk the uncertainty of going to court.
Okay. And Jared, on frustration?
Yeah, I think the three key things to consider with frustration are: what was the contract about? What is the root of the contract? Does COVID-19 bite on that? And was something like COVID-19 in the contemplation of the parties? And the key, therefore, is, in light of those three key considerations, to go back to your contract. Although we said at the top of this that frustration isn't a creature of contract, nonetheless, it'll be vital as soon as you are starting to think along frustration lines to go back to the contract and indeed the surrounding communications to get your evidence together as to your position as to what the contract was actually about, whether COVID-19 can affect that, and whether or not COVID-19 or something like it was in the contemplation of the parties at that time.
Okay, thank you very much, Jared and Ross, for your input today. If we could go to the last slide on the presentation, you'll find this is the key contact sheet. These photos were obviously taken when we had access to hair, makeup and beauty. I'm afraid that we don't have access to that today, so my apologies if you're offended by our unkempt appearance. We hope that we will all come out of lockdown and be able to meet again. Thank you for attending today and taking the time. We will try and answer the questions. If you do have any specific things which you've taken note of during the presentation that you would like some more information on, then please use the Q&A to do that. We're going to leave the meeting now, but you will be able to keep on putting some points into the Q&A, and we will come back to you on that. Thank you very much for coming along today.